So a new request has been made to the Supreme Court for them to issue an emergency injunction against a state's rifle and magazine ban. And the really interesting thing about this emergency request is that the state involved cannot oppose it. So let's talk about what is now happening in this critical case. But real quick before we jump into this video, if you think a rifle and magazine ban is clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to mention that the Gundy's Awards voting is once again open. They're actually going to end at the end of this week, so I would appreciate your guys' vote if you guys think I deserve to be voted for. I'm in 2 different categories, the top 2 voices and then also Influencer of the Year. You can vote every single day in 15 different categories, and each vote actually enters you to win a bunch of prizes. So again, if you're interested, you can check out the Gundy's voting down below. I will leave links, and I would appreciate your guys' votes. But regardless, thank you guys so much for all of your support. So like I mentioned in the intro, in this video, we're going to be breaking down an important situation that is now up for Supreme Court consideration. A new emergency writ for an injunction has been filed to the US Supreme Court, and the court is being asked to step in once again temporarily and enjoin a ban on so-called assault weapons, essentially a rifle, and then also a standard capacity magazine ban. This case we're going to be breaking down is a case we've talked about before, and it's the Culkins v. Pritzker case. This case involves a challenge to the Protect Illinois Communities Act, also known as PICA, which placed an unconstitutional restriction on rifles and magazines. PICA also requires a registration requirement and deadline for some rifles to be grandfathered in, and that has to be met by a registration period, which essentially ends on January 1st of 2024. So time is very much of the essence in this case and other cases as well. Now, this specific case, Culkins, is currently set for Supreme Court conference on January 5th, but of course, that really doesn't help those individuals in Illinois since the registration deadline ends on the 1st of January. Well, now the plaintiffs in Culkins have filed a request for an emergency injunction in the US Supreme Court, which would halt the law at least until the Supreme Court reviews this case at conference and decides what they want to do after January 5th. And even more interestingly with this specific emergency injunction is the fact that the plaintiffs argue that the state of Illinois has waived any ability to oppose this emergency injunction. Essentially then, this would be a one-sided request that the state cannot oppose. The plaintiffs argue that by default, that means that the Supreme Court should in fact grant this temporary injunction, which would be in place at least until after January 5th. Now, this case has an interesting background, which also seems to have intrigued the Supreme Court, at least enough to where they have sent this for conference again in early January. This case challenges PICA, which is again the state of Illinois' Protect Illinois Communities Act. And originally, this case was brought in an Illinois lower court. It's a state court challenge. And judgment was entered in favor of the plaintiffs against the state of Illinois. In response to losing that case, the state of Illinois appealed the decision up to the Illinois State Supreme Court. Now, here is where things get a little bit interesting, a little bit more nuanced in this specific case. Illinois Supreme Court has 7 judges that sit and review all of these cases. 2 of those judges, Judges Rochford and O'Brien, who were elected into office in November 2022, also reviewed this case. Now, during their election process, both of those judges received substantial campaign contributions, not only from the governor, who is a defendant in this case, but then some additional information came out that there was even more money that was then also sent to those judges who sat and reviewed this case, and that money potentially came from some individuals also affiliated with the defendants, including one of the defendant's attorneys. And the argument was made that because of these campaign contributions and potential bias, that these 2 judges should have either been disqualified or recused themselves. And so the plaintiffs here filed for a request for disqualification and a request and motion for recusal. However, on review, the Illinois Supreme Court denied the motion to disqualify, finding that they had no rules that they could themselves disqualify those judges. Instead, it was up to each one of those judges to decide if they needed to recuse themselves. And of course, those 2 judges did not recuse themselves from the case. And ultimately, in a 4-3 decision authored by one of those non-recused judges, the Supreme Court of Illinois decided to reverse the lower court's judgment that invalidated the PIC Act, and invalidated this rifle and magazine ban. And it's this case and those interesting facts that have now made their way up to the US Supreme Court with the original writ assert in the Supreme Court, and then now also this emergency request for an injunction. Now, what is critical for what is happening now in this case is the fact that the state of Illinois originally filed a notice of waiver to the Supreme Court when the first writ assert was filed. In the waiver, the state of Illinois identified that they are not going to file a response, and they were not going to file their response brief that was originally due on December 14th. In response to that, the Supreme Court essentially agreed, said, okay, you're not going to file your response. We're just going to accept that waiver, that notice of waiver, and then send this case to conference, which is set on January 5th. But I think the state of Illinois might have made a big mistake, and the plaintiffs are now trying to capitalize on that mistake. The plaintiffs in this Culkins case have now filed for their own emergency injunction, which they argue should be granted and remain in place at least until the Supreme Court reviews and decides what they want to do with this case at that January 5th conference. They also argue that the state of Illinois has waived all ability to refute or oppose the facts that are now being used and presented in this emergency request. Now, in this emergency injunction, the plaintiffs argue that by waiving their right to respond to applicants' petition for a writ of certiorari, Pritzker waived response or objection to a misstatement of fact or law, or objection to consideration of a question presented in the petition for writ of certiorari, and said petition for writ of certiorari is subject to distribution and available for review in support of this application and as such incorporated herein. They go on to make their argument for why a temporary injunction should be granted in their favor and why the Supreme Court should in fact grant this emergency relief. They include arguments that they're likely to succeed on the merits, that it's in the public's best interest, and those are the traditional legal factors that you have to show to get some sort of injunction. Again, they present this almost as one-sided and a slam dunk, and it's almost a slam dunk request is what they're arguing, since the state of Illinois has originally issued that notice of waiver. Again, this is a really interesting use of the state's prior concession and their notice of waiver to try to win this emergency injunction now in a different request. The plaintiffs here in this request conclude by stating that the applicants have established all the elements required to demonstrate that they are entitled to injunction against Pritzker, barring enforcement of the Illinois assault weapon partial ban until final disposition of the case number 23-510 and the stay of the August 11th, 2023 Illinois Supreme Court opinion reversing the March 3rd, 2023 Circuit Court final judgment invalidating the ban. Therefore, they respectfully request that the Circuit Justice grant the application or refer it to the full court for consideration. So what they're arguing there is that there was a waiver originally in this case, in the original case filing that's attached to this new filing. The state of Illinois waived that. It's going to conference. And now the plaintiffs here are filing an emergency request saying, hey, look, the state of Illinois is already not defending this. It's going to conference. We think that we are going to be harmed. We need some sort of emergency relief, at least until you review this case and this issue at conference. And yet again, and they're pointing to the fact that the state of Illinois has waived any response. So the Supreme Court here should almost take this just as a one-sided argument, take this as the facts that were submitted were not defended against by Illinois, and therefore the Supreme Court should just accept what is being argued in this one-sided brief right now and grant the emergency injunction. So this is definitely an interesting situation where you have the Culkins plaintiffs seeking emergency relief. What they want is emergency protections and temporary injunctions, at least until the Supreme Court decides what they want to do with this case after that January 5th conference. Again, I want to mention that you have the NAGR case that is also seeking emergency injunctions and reliefs. The whole goal is to stop this law from going into full force and effect on January 1st, but I do want to temper everybody's expectations. The Supreme Court traditionally does not like to get involved early in these cases, especially recently in 2A cases. The Supreme Court has denied these types of requests and has not been interested in getting involved. But there's a lot of interesting things that are developing in some of these cases, including this Culkins case, and a lot of cases are now submitting emergency relief to the Supreme Court. The Supreme Court is taking conference and reviewing some of these cases. So it seems at least like they're a little bit interested in these cases, but we'll have to wait and see. And of course, if anything else develops, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.